this year to the Companies Act regarding beneficial ownership. Our presenters this afternoon will be Mrs. Inga Hainsley-Bennett, AML/CFT Manager here at the Companies Office of Jamaica, and myself, Amanda Wallace, Legal Officer here at the Companies Office of Jamaica. So just to give you an idea of what we will be going through this afternoon, we will start with a brief introduction to the presentation. From there, we will have a look at the current beneficial ownership regime. That is, what are we doing now regarding beneficial ownership? Next, we will go through the obligations. I'm sorry, I think that got a little misplaced. Next, we will be looking on identifying a beneficial owner. And then after that, we will be going into new obligations on companies and the COJ's new role. Finally, we will look at what to expect from the rules and next steps for companies currently incorporated under the Act. So without further ado, let us begin. So as mentioned before, we do have a beneficial ownership regime currently in place at the Companies Office and under the Companies Act. This regime commenced with the Companies Amendment Act of 2017. And what this Amendment Act did essentially was require that companies provide beneficial ownership information to the COJ. Now, in reviewing this regime, this beneficial ownership regime that we currently have, the Financial Action Task Force, FATF, determined that all types of companies needed to provide beneficial ownership information, not just companies limited by share capital. And additionally, the regime here at the COJ and under the Companies Act was severely lacking in many respects. So it needed to be more extensive. As a result of this review and the findings of this review, the COJ partnered with local and international stakeholders and embarked on a project to revise the current beneficial ownership regime under the Act and here at the COJ to ensure that the provisions met international standards set by the Financial Action Task Force. Now, these amendments, when passed into law, because currently we're working on them, they're pending. We just have a bill at the moment. But when they are passed into law and they become a part of the Companies Act, it is expected that they will ensure greater transparency in corporate governance and reduce the risk of legal persons such as companies being used for various financial crimes such as money laundering, terrorism financing, that sort of thing. As I've mentioned before in this introduction, these amendments have not yet been passed into law. We are still drafting the bill. We're still at that stage, but it is expected that it will be passed into law before the end of this year, 2023. So moving along to the current beneficial ownership regime. As mentioned before, we do have a regime in place. It was lacking per the review of the Financial Action Task Force, but let us show you a little bit of what this regime is. Most of you, you're probably familiar with it already, so that is great. But for those who aren't, we'll do a little refresher as to what the Amendment Act of 2017 brought into place when it was passed regarding beneficial ownership. So, as mentioned before, the Amendment Act of 2017 established the general requirement for beneficial ownership information to be collected and recorded by the COJ. It amended various sections of the Act. We'll just look at a few. For example, Section 109, it required that the Register of Members must include details on beneficial owners. It amended Section 116 of the Act to require that where companies receive any notice of trust that affects the membership of the company, they shall collect and record beneficial owners of same. It amended Section 122 to require beneficial ownership on the annual return form. It also amended Section 363 to require that beneficial ownership information be submitted on the registration documents of overseas companies. Now, the Amendment Act of 2017 required only companies limited by share capital to provide this information. So this meant that for the Form 1A and the Form 19A, Form 1A being the incorporation document and the Form 19A being the annual return form for companies limited by share capital, beneficial ownership information has to be stated on both those forms. Also, there was no requirement for companies limited by share capital to give us notice of changes in beneficial ownership and membership information, right? Now, the only exception to that latter point would be the Form 9, which is the return of allotment form. Whenever a company filed a Form 9, they were required to tell us, well, they are currently required, I should say, to tell us who the beneficial owner is for the shares allotted. Right. So that would be the only exception in terms of notification regarding beneficial ownership changes to a company, currently at least. The COJ, does not verify beneficial ownership information currently. So we take the information as it is. We don't check to make sure that it is true. And the information that we collect is limited to just the name, the address, occupation, and the nationality of the beneficial owner. Further requirements would include that persons who take up 50% or more interest in the company would have to state who the beneficial owner is or who the beneficial owners are of those shares so taken up. Emphasis should be placed on 50% or more issued shares, right? Also, there's a requirement to state who is the beneficial owner of the company and the shares. So that's a dual obligation, right? So not just the shares, but also the company. There is also no explicit sanction per the Amendment Act of 2017 for not stating beneficial ownership information. There is, however, the implied one of non-registration. So in the case of a new company being formed, registered, and incorporated, there is the implied sanction that it will not be if the beneficial ownership information is not provided. And in the case of, for example, annual returns, the Form 9, those documents will not be registered if, of course, you do not provide the beneficial ownership information. And lastly, the current regime abolished bearer shares. So having gone through all those requirements that the Amendment Act of 2017 established, the FATF reviewed them. And just a little quick point here, the FATF, for those who don't know, Financial Action Task Force, they are almost like the watchdog for global money laundering and terrorist financing. And they are responsible for coordinating global responses to prevent organized crime, corruption, and terrorism. Now, in performing these duties and when they conducted their review of our beneficial ownership regime, which I just summarized for you, they found that our performance, our referring to Jamaica's performance in relation to beneficial ownership was lacking. Therefore, we were gray listed. Now, the ultimate consequence of being gray listed is that we will be blacklisted if we do not make changes by the EU, which is the European Union, right? So now we're on the gray list. We have the opportunity to make some changes, do better, ensure our system is a bit more strict to ensure the prevention of certain financial crimes. So in light of the review conducted by the Financial Action Task Force, the Act is now being revised, right? And we have summarized for you the general points of amendments being made. These, of course, is not a closed list. It's not everything. We don't have the time to go through everything, but we have itemized the most important ones, right? And these I'll now go into each one as they arise. So the first thing that we're going to look at is the threshold. So you would recall previously when I stated that persons having 50% or more of the shares in a company would be required to state who their beneficial owner, who the beneficial owner is for those shares. Now we've lowered that threshold to 25% or more. So it's no longer those holding 50% or more shares, issued shares. It's now 25% or more issued shares. The beneficial ownership information that we collected, you recall I said that was name, address, occupation, and nationality. That will now be extended to collect other pieces of information, such as date of birth, tax registration number. If there's no TRN, then you can provide the tax ID. In lieu of that, you can also provide the passport or driver's license number. So those are some additional pieces of information that we're now collecting. The powers of the registrar will be extended or expanded, I should say, to require the registrar to conduct investigations to verify beneficial ownership information. So we're no longer accepting the information as you give it to us. We're going to be investigating it and making sure that what you are actually telling us is true, right? There's also the requirement to state beneficial owners, the current requirement to state the beneficial owner of shares is going to be removed, and now companies will only be required to state the beneficial owner of the company. So you won't have to state who. So for example, if you have 4 shareholders, each of them being issued different amounts of shares, you won't have to necessarily state the beneficial owner of each shareholder or the shares that each shareholder holds, right? You'll now just be required to state who controls the company overall, generally. There will also be an increase in the fines and penalties that will be issued to persons if they fail to comply with these obligations. A lot of the fines are outdated and they're no longer effective in dissuading persons from non-compliance. So we're increasing that amount now to in turn increase effectiveness of the sanction, the monetary sanction. Companies will now be required to keep beneficial ownership information even after the company is closed. So now, currently, when a company is wound up and is closed, or in the case of where it's struck off by the registrar, you'd still be required to keep beneficial ownership information even after that. There's also the amendment that establishes a new standard for beneficial ownership information, right? So we're not just collecting the information and that's it. We have to check the information to make sure it is up to date, adequate, and accurate. So that's a standard for the information, the beneficial ownership information that we're trying to implement now. And lastly, and perhaps definitely not least among all of these, is that providing beneficial ownership information will now apply to all companies. So earlier, I would have stated that our current regime only requires that companies limited by share capital provide beneficial ownership information. That is being expanded now to all companies, right? So companies limited by guarantee with share capital, companies limited by guarantee without share capital, unlimited companies, you are all now required to provide beneficial ownership information. So having an understanding now of what is and what is to come, we can go into, well, how do I identify the beneficial owner in my company or within a corporate structure, right? So the next slide will explain to you a very useful test. It's very practical, very simple, just 3 easy steps that you can follow to really zero in on who the beneficial owner is or who the beneficial owners are in your company. So just a simple definition of the term beneficial owner. And just to clarify, we are revising the definition of beneficial owner. That definition, we're still in the process of putting it together. So just for the purpose of this presentation, we have provided you with a very simple definition that should give you a very good understanding of what the term means, not necessarily limiting it to what will be placed in the act itself. right? And the definition we have provided here is a beneficial owner is a natural person who ultimately owns or controls a company. Very simple, just a few words, right? So key words that we should remember: natural person, ultimately owns, and controls, right? Just some key words or phrases to remember from this definition. So let us establish, before going further, that a beneficial owner must be identified. There will be no exceptions. So you will not be able to come to the company's office and say to us, well, performed your test, but I still can't find a beneficial owner. That is unacceptable, right? You must identify the beneficial owner of your company, and you will be required to provide their information to us, right? No exceptions to that rule. So the test, what is this test I have been referring to throughout this presentation? So we refer to it as the cascading test, right? And this is a test that you must apply in identifying your beneficial owner, identifying the beneficial owner within a corporate structure. It has 3 steps. The first step, ultimate ownership. The second step, ultimate effective control. And the last step, highest management authority. Right? So you will have to go through each of these steps depending on, how it applies to your company to see who is the beneficial owner within your corporate structure. So let's look at step 1. So step 1 is a primary method to identify who the beneficial owner is, right? And to first identify the point is to first identify all individuals who ultimately have a controlling ownership interest that is 25% or more, and we spoke about that earlier being the threshold, right, in the company, whether directly or indirectly, through directly meaning in their own name, or indirectly meaning through a chain of other entities or arrangements. So that really goes to ownership, right? Who has 25% or more interest in the company? That's the first step, right? So you have to identify those individuals first. So where there is doubt as to whether those persons identified in step 1 are not truly the persons controlling the company, right? Or if you are unable to identify such a person because, say, for example, the company does not have share capital, then you would move on to step 2. At step 2, step 2 refers to the persons with the controlling ownership interest. I'm sorry, I misread. So where there is doubt as to whether the persons with the controlling ownership interest are the beneficial owners, as I stated before, or where no natural person exerts control through step 1, as we went through already, the beneficial owner shall be the natural persons exercising control of the legal person through other means. So this is ultimate effective control. Now, having gone through ultimate ownership, ultimate effective control, and you're still unable to identify the beneficial owner, then you can proceed to the final step, which is step 3. So where there are no natural persons exercising A, ultimate ownership, we went through that at step 1. B, ultimate effective control, we went through that at step 2. Companies should identify and take reasonable measures to verify the identity of the relevant natural person who holds the position of senior managing official. So we go from ownership, which is 25% or more, interest or voting rights. Then we go to step 2, ultimate effective control of the company. And then we go to step 3, which is the last step, senior managing officials. So just a look at some examples then under these 3 steps. We have here an illustration, right? We have the starting point and we have the end point. At the starting point, ultimate ownership, 25% or more of issued shares. That is important, issued shares, not shares authorized to be issued, but issued shares or voting rights. And then from there, we go to ultimate effective control, and this would include persons who can appoint or remove directors, or even persons who determine the policy of the company. And this, of course, is not a closed list in terms of what ultimate effective control means, but it's just to give you an idea of the type of persons we look for under this particular step. And lastly, effective control of the management of the company. So you think of high-ranking management officials. So you look at persons like the general manager of a company, the chief executive officer, the chief financial officer, operations manager. These are persons who would be considered senior or high-ranking members of the management of the company and would qualify under the third step of the cascading test. So in applying this cascading test, there can be multiple beneficial owners. So when you apply the test, it doesn't mean that you're only going to get one person, right? Several persons can be the beneficial owners of a company. So we're going to look at some examples at where this can arise. So let's look at the first one. So in example number 1 here, we have company A, let us call it company A, being incorporated, and the company A has many shareholders, right? They have, let's name her Mary Jane. Company A has Mary Jane holding 20% shares. And then they also have company B holding 20% shares. Now we would have gone through the definition and the threshold before, and we would appreciate that neither of these persons, that is Mary Jane or company B, would qualify, right? Because they don't have 25% or more. But we have John Brown on the right of the screen here, and John Brown has 30% shares in the company. So he would check the box there for stage 1. He has 25% or more. So automatically we can determine that John Brown is a beneficial owner of company A. Company A being the company being incorporated. I hope you're following the illustration here with company A down here. All right, so John Brown, we can determine that he is a beneficial owner. He has 25% or more. But then there is the case of company C. Company C is a corporate shareholder as well, and they have 30% or more. So you may say, well, should I list company C? I'm sorry. Should I list company C as a beneficial owner of the company being incorporated, right? And of course, the answer is no, because what did we establish in the definition of beneficial owner? That it has to be a natural person, right? It cannot be a legal person. So we can't put down company C as a beneficial owner as well, even though they have 25% or more shares in the company. What we have to do is we have to examine the corporate structure of company C to say, well, who is the beneficial owner of company C? And we could name this gentleman here David Smith, right? So let us name him David Smith up top here. So David Smith is beneficial owner of company C, right? If that is the case, then David Smith would also be regarded as the beneficial owner, or as one of the beneficial owners of company A. And just to clarify, David Smith would be the beneficial owner of company A through indirect means, right? And John Brown over here, we identified him earlier on as being a beneficial owner because he has 25% or more. He would be a beneficial owner through direct means. So remember, we had said direct means where their name is actually shown there. So he's directly a beneficial owner by virtue of his interest in company A. But David Smith up top, right? He would be indirect because his ownership goes through different arrangements or legal persons. In this case, his ownership goes through company C. So by virtue of his affiliations with company C, and his overall control of company C, that is how he's come to be the beneficial owner of company A. So I hope that is clear. This is one scenario in which you can have several beneficial owners arising in a company. Another scenario is in a company limited by guarantee without share capital. Now, let us, for the purpose of presentation and discussion, say that the company being incorporated in this example is a church, right? So we have a church shown at the bottom of the screen here being incorporated as a company limited by guarantee without share capital. Now, in such a case, they will not be able to apply stage 1 of the cascading test, because remember we said stage 1 would apply to companies with share capital. So if this company does not have share capital, they can't start at stage 1, they'd have to start at stage 2. Now, in starting at stage 2, let us say that this company has identified that the persons with ultimate effective control of the company, that is, they look on some examples, which is that the persons who determine the policy of the company, the persons who, let's go with that, who determine the policy of the company, those persons are the board of directors, right? Now, the board of directors obviously would be more than one, that would be more than one person. So they would go on to list each member of the board as being a beneficial owner of the company. And this beneficial ownership would arise as a result of the board of directors having ultimate effective control over the company, right? So that is another way in which you can have several persons being the beneficial owners of a single company. So having gone through very briefly, but we still did go through, just a quick recap. We went through what is currently being done, right? We went through what the 2017 Amendment Act brought. And after that, we looked at the fact that the Financial Action Task Force reviewed what we are currently doing in our beneficial ownership regime and said, well, this is insufficient. As a result of the Financial Action Task Force saying that it is insufficient and Jamaica being gray listed, we have embarked on a project to revise the current beneficial ownership regime to ensure that it is effective in preventing financial crimes such as money laundering, terrorist financing, right? We went through a few of the amendments: lowering of the threshold, revision of the definition, expansion of the registrar's powers, the fact that you will only be required to remove, you'll only be required to list the name of the beneficial owner for the company, not the shares, right? We went through all of those things. And then lastly, just now, we went through the cascading test, right? And that is how to identify the beneficial owner in a corporate structure. So having gone through all of that, and we can now appreciate all of that, from there, we're going to look at, well, what are the obligations on companies and what is the new role that the COJ will play when this act is passed. So I will now hand over to Mrs. Inga Hainsley-Bennett. I introduced her earlier on, but for those of us who came in a bit late, Mrs. Inga Hainsley-Bennett is the AML/CFT manager at the Companies Office of Jamaica, and she will be taking you through the remainder of the presentation. Thank you.
Yeah. Okay, good afternoon, everyone. Thank you, Amanda. Okay, so having just gotten all the information as it relates to the change in the definition of beneficial ownership and the expansion of the designation to not just companies with shares, but to all companies that are registered with us at the Companies Office, we're going to look to see now how this impacts on the obligations for companies, and also what is going to change with how the Companies Office does business with you. We're going to look at the obligation to collect, maintain adequate and accurate, up-to-date beneficial ownership information and what that will entail in terms of the level of information required, the level of detail that will now be expected. We look at the obligation to notify the registrar of changes to beneficial ownership information. And then we'll also look at the obligation to retain the information and what is the minimum prescribed period to retain this information. All right, so let's look at keeping and collecting beneficial ownership information. Now, currently, we are collecting, as Ms. Wallace had said earlier, just information from companies with shares. And as we now expand that to all types of companies, we will also expand on the amount of information we are collecting. So we will collect the name, the nationality, the address, and the occupation of the beneficial owner, but we will also now start to collect the date of birth of the beneficial owner and their TRN. And so this information will have to be provided by the company at incorporation. And then following from incorporations, companies will also now have an ongoing obligation to maintain and ensure that the beneficial ownership information held here at the company's office is adequate, accurate, and up to date. And so we'll speak a little about what that means. Now for adequate, and these will be defined in the Act, for clarity. So this is just a very, very, very summary view of what this is. So for the adequate beneficial ownership information, the understanding is that it will be satisfactory or acceptable in quality and quantity, and that quality and quantity will be defined in the Act. The accuracy, it must be correct in all detail, that is all detail that will be required, and it must be exact without any mistakes. And then it must be up to date. So it must be current and accurate information up to the time when it is presented to the registrar. So now that we're going to start collecting not just name, address, nationality, and occupation, but also TRN and date of birth, the question will arise, where an individual does not possess a TRN, what do I do? Well, in those instances, then a passport number will have to be provided to us, or a driver's license number may also be stated. So what we're doing right now is that we require no additional information other than the name, address, nationality, and occupation. But going forward, we will be asking for the TRN. And where the persons are not Jamaican nationals who do not have TRNs, then they will have to provide a passport number or a driver's license number, but some method of identifying who the beneficial owner is will have to be provided and will be one of the requirements that are coming out of the amendments to the Act. Notifying the registrar or the company's office of changes to beneficial ownership information. Right now, persons are providing us with beneficial ownership information on our annual returns, as well as at incorporation. Those are the only two instances which persons are currently providing us with beneficial ownership information. However, the provisions that are being proposed will require that companies notify the registrar of any changes in beneficial ownership information on the register of members and beneficial owners within 14 days of the change. And these changes include a change in name, change in address, change in shareholding, and occupation. 1 minute, and occupation. Go back, Amanda. Thanks. Okay, and of course, in keeping with the notification of changes, where an existing beneficial owner ceases to be a beneficial owner, the company also now has an obligation to notify us of that change. Where there is a new beneficial owner, the company now has an obligation to notify us that there is a new beneficial owner and that the person has ceased. And so similar, if one can recall, or Form 23, where one would notify us of a change in directorship, it is in a similar provision, similar obligation that now arises as it relates to changes in beneficial ownership information. You can proceed, Amanda. Keeping and retaining the beneficial ownership information. So companies will be required to keep a record of the beneficial ownership information and the measures taken to confirm the accuracy of the information for a minimum of 7 years from the day of the last business transaction is conducted. So there is now the minimum requirement to keep all the information on beneficial owners for 7 years, minimum 7 years. You can proceed. Now, coming out of the review of the Companies Act and the amendments as it relates, the current amendments as they relate to beneficial ownership requirements, Ms. Wallace would have explained that the Financial Action Task Force would have reviewed that Companies Act or the existing Companies Act and found it wanting. And as such, there are some new sanctions that are being proposed. And these sanctions include penalties for failure to maintain adequate, accurate, and up-to-date beneficial ownership and membership information in the register of members. Other sanctions include increasing fines and sentencing guidelines for officers and companies that are not compliant with the provision of beneficial ownership information. There are going to also be penalties, fees, fines, for failure to correct beneficial ownership information where it is identified that there is an error with it. So the information filed here at the company's office. So where it is detected that there is an error with the information or information has been misstated, it means therefore that when we notify you and there is no change, there will be a penalty associated with that. And proceed. Again, with the penalties, we move on with a little more detail. So there'll be monetary penalties as it relates to the officers of the company. And these include such things such as failure to keep a register of members, failure to notify the COJ of a change in the register of members, failure to notify the COJ of the location of the register of members, failure to give the COJ access to inspect or examine company documents in relation to the register of members and beneficial owners, and failure to provide the COJ with further or additional information requested. So you're seeing a little change there in the role of the registrar, which we'll speak to a little later. Other sanctions under being struck off the register: failure for 5 consecutive years to keep a register of members, failing for 5 consecutive years to keep an adequate, accurate, and up-to-date register of members, failure to comply with 3 warning letters issued regarding an annual return. There are some periodic monetary penalties as well: failure to keep information in the register of members accurate and up-to-date, and failure to file annual returns. And there will be some new processes that relates to warning persons or notifying persons where there are delinquencies or where there are issues with compliance notice. And so we have failure to file an annual return in 100 days, failure to comply with the first warning letter, failure to comply with the second warning letter from the company's office. There is also loss of a compliance status at the Financial Services Commission and the Bank of Jamaica, and that has to do with failure to file an annual return on time. All right, so we got a slight glimpse of what some of the sanctions are, and we can see that it's turning a little on the company's office, seeming to be looking into some of the documentation at the locations. And so the COJ's role is evolving with the proposed amendments to come. Now, the FATF recommendations require that the COJ be granted legal powers in order to monitor and verify beneficial ownership information held by companies through inspections and investigations. So consequently, it is being proposed that a new section 109A be inserted into the Act to set out the powers to be granted to the registrar. And these powers will empower the company's office to verify beneficial ownership information In an effort to achieve this, the COJ will be also empowered to investigate the records and the books of companies to ascertain the information needed to verify the beneficial ownership information. And how is this going to be achieved? So within the company's office, we have established a new department, and it's our anti-money laundering and counter-financing of terrorism department. It becomes the investigative arm of the registrar. The department is responsible for ensuring that the information received by the company's office in relation to persons exercising ultimate ownership and control of companies is accurate and up to date by adequately and actively verifying, monitoring, and implementing other measures, my apologies, to ensure the consistency and reliability of the register of members and beneficial owners. And how will we do this? So very quick snapshot. So we'll be conducting detailed examination and verification of the beneficial ownership information provided on the documents that are filed here. We will also be conducting field visits to audit companies' registers of members and beneficial owners. We will be preparing and issuing registry notices and reminders, and providing a pool of referrals to inform our investigation or legislative and or removal proceedings based on the compliance issues that may arise. Notifying companies of any registry discrepancies in beneficial ownership information and membership information. And this is different from our usual approval of an annual return. This speaks specifically to the information that is provided on the beneficial owner. So the name, address, nationality, and occupation, their date of birth, TRN, and any other supporting documents that will be required in the act to prove who this person is. So that is the information that we will be notifying companies about. That is where the discrepancies will lie. So it will be different from what you're accustomed to, where somebody will say your annual return has been rejected and needs to be amended because you have you've not noted the movement of the shares, or you have stated a class of shares incorrectly. These these activities of the registrar will relate specifically to the information provided on the beneficial owners. And finally, the processing of all incoming investigative requests as it relates to companies from our external stakeholders and competent authorities. Now, also coming out of the Financial Action Task Force requirements is that the country set up a beneficial ownership registry. You are familiar with the company's registry, which you can access either in our offices or you can access online. What we will be also setting up is a beneficial ownership registry. And what is proposed in the Act is that this registry will be established to show the beneficial ownership information on each company. So as beneficial ownership information is collected on the forms, then specific groups will be able to access the information through a search on this specific register. Now, one of the things that is also being proposed is that the beneficial ownership information will be private information. And so the dynamic where those of you who are filing with us regularly will know that some information is private on the forms and some information is public. What is being proposed also is that this entire set of information about beneficial owners will become private. And so how it is presented will be different. And so the registry that we will create, the beneficial ownership registry, will allow persons to access the information in only the private information under restricted circumstances. You can proceed. So there'll be two tiers of access. So the two tiers of access will relate to the private information on beneficial owners. The complete access is given to competent authorities, and restrictive access is for private and public entities. Some persons will be able to just verify information while others, such as law enforcement, will have complete access to all the information. To access the beneficial ownership registry, one will have to make an application to the company's office, and the grounds for the application to have access to this information will be whether you're functioning as a law enforcement or regulatory authority, if a body is conducting an investigation, or someone is conducting a civil or legal proceeding. So competent authorities include institutions such as the Bank of Jamaica, the Financial Services Commission, the Real Estate Board, the Betting and Gaming Lotteries Commission, the Public Accountancy Board, Senior Gaming Commission, and any other regular authority designated as such by the minister. Now, entities that can apply for access include our law enforcement authorities, regulatory authorities, and our non-governmental bodies. What is also important here is that where this registry differs from our company's registry is that what you will see happening when the Act amendments are passed is that the information will be stripped away, and the form will only have the traditional information such as directors and shareholders, and the beneficial ownership information will be separated because that information will no longer be viewable to the public, only through access to the special beneficial ownership registry. You can proceed. All right. Now, because of the extent of these changes, not just to the Act as was done the last time, but to the Act and the company's rules, we're giving you a little snapshot of what to expect from the regulations. So what will be contained will be maintaining beneficial ownership information in the register of members. It will speak to the duties of companies. It will speak to the duties of legal owners and the duties of the beneficial owners. The rules will also include how to identify a beneficial owner in different corporate structures and also where there is a chain of corporate structures. It will speak to filing of beneficial ownership and membership information. It will speak to how the registrar will verify and inspect. It will speak to those powers. It will speak to the notices that we will send and the measures to ensure that there is adequate, accurate, and up-to-date information. It will speak to the register of members, the register of beneficial owners. And of course, there are going to be, I know Ms. Wallace said that there are no exceptions, but where there are exceptions, they will be contained within the rules. Thanks. Now, what are we going to be doing to ensure that everybody understands and moves smoothly into the new regime? Is that we'll be providing various tools to help you understand the new amendments. And so we will be issuing a guidance note as well as having numerous sensitization sessions. This is one of many because you will appreciate we have not discussed in any detail what is in the Act, because what we are giving you is just an overview for you to understand what is coming, what are the proposed amendments as it relates to when the Act is passed. The sensitization sessions will continue. And proceed. All right. So what are we expecting companies to do for the upcoming amendments? Now, although the new amendments have not yet been passed, companies can start to prepare for the new obligations by doing the following. Well, first, you want to explore and acquire software, possibly, to manage member and beneficial ownership information and due diligence documents. One of the things that I mentioned earlier was that we will be requiring date of births, we will be requiring TRNs, and where persons do not have that type of information, we will be requiring some document with some form of identification for the beneficial owner. And also, I spoke about notifying the registrar of changes. So it means that the proposed amendments go as far as saying where an ID has expired, you will need to notify the registrar and provide us with an updated version. So there will be some amount of management of member and beneficial ownership information that will have to happen. So that's something that you can start thinking about. Identifying all the beneficial owners of the company. And so Ms. Wallace would have taken you through the cascade test, and of course, understanding that we're starting from a position of ownership for companies with shares where there is nobody who meets the threshold of ownership, and you're moving into ultimate effective control, and where there's no one who meets that tier, then you move to the final tier, which is the highest management position or authority in the company, which could be not just one person, it could be a board of directors. So what we want is for persons to start addressing their minds to the fact that you need to identify all the beneficial owners of the company. Also, we want you to start thinking about ensuring that the information that you have on the beneficial owner is accurate and up to date. And so that would include, of course, identification information. So whether it's IDs, whether it's the addresses of persons, that information you'd want to ensure that it is up to date. Seek out and insert any missing beneficial ownership information that may exist now in your existing registers. Prepare to file any information that you found to be missing with the company's office when the time arises. And of course, getting all the required information on the members updated in the company's register. All right, also updating your compliance obligation of existing companies. So your packages that you will have for persons who you are, your clients, persons who are forming companies, persons who are, filing annual returns and you're assisting them. Ensure that you update those packages, because now we'll be requiring more information. Amend any incorporation questionnaires that you have, because again, more information will be required, more documents to support that information is going to be required. Set up a systematic approach to verify membership and beneficial ownership information. And of course, as it relates to changes in that information, because that is a new dimension. Typically, you are notifying us of changes with secretaries and directors, and now you will be notifying us of changes in beneficial ownership information. Amend your articles, possibly, to provide for compulsory buyback of shares where it is that there's a failure to cooperate in providing the information. This is, of course, just a suggestion, but it is something that could be explored, because we did look at the sanctions, albeit simplistically, there are a lot of sanctions to the companies, to the officers, where the information is not provided, or where the information, when inspected, has inaccuracies or inconsistencies. All right, so we're at the end. Thank you very much for listening. And I would imagine that there are maybe some questions. So we will take any questions. You can maybe type in the chat and we will respond to them.
Just to point out, Mrs. Bennett, before we get to the questions, our PR officer has just requested that you complete a survey. It's just a quick survey, maybe about 10 questions, just to let us know how this sensitization session went for you. We value your feedback. It is imperative that you understand the incoming beneficial ownership regime. And if there is more that we can do to facilitate your learning, we are willing to work with you on that. So we encourage you all to complete the survey. I believe the link to the survey is posted in the chat. Please go ahead and click on it and just complete it. As I said, we value your feedback. So thank you for that. You could go ahead, Mrs. Bennett.
Right. So I guess if there are any questions, persons could type in the chat so that we could respond. How do these changes affect public companies and publicly listed companies? At this moment, because of course the act is not yet passed, the proposal is that there may not be any exemptions for the public companies, but there is a lot of suggestions around that there should be an exemption. However, for now, there are no exemptions as it relates to public companies, publicly listed companies or public companies.
Right, and just to add, whilst there are no exemptions currently for public companies regarding the filing of beneficial ownership information, we are considering, and it will possibly be passed in the act, that public companies will not be required to give us notice of changes to membership, right? Because we understand the difficulty that that would pose. You have thousands of shareholders, so it is possible that you will be exempt from notice of changes to membership, right? But you would still be required, I believe, to give us notice of beneficial ownership information. There was a question just before that regarding public access to the register. That is still being discussed. Currently, it is being proposed that there will be no public access to the register of beneficial ownership information. Access will be based on the different groups of persons we mentioned: competent authorities, regulatory authorities, law enforcement, and it is possible that that will be expanded to accommodate financial institutions and designated non-financial institutions as well. But that is all still in discussion, and that is a possibility. Just to answer your question there.
Yeah.
There was a follow-up question: will these changes affect charities? So as mentioned in the presentation, all types of companies will be required to file beneficial ownership information. So that would include companies limited by guarantee without share capital, which is the form of company that charities normally take. So yes, they will be affected as well.
Okay. Okay, so the other question is, as it relates to the timeline to file changes in information, what is the time period? All right, so, all right, could someone mute their mic?
I'm here when it's
Hello?
Could what if
All right, so the question as it relates to timeline to file changes, the act has not been passed as yet, as you know. So whether it relates to a transition period or not, that is not, we don't have that information at this time. But as we progress towards the amendments being passed, the Companies Office will notify the public as it relates to any specific grace periods before the act takes effect.
Okay, Mrs. Bennett, there is a question from Tracy C. that says, how do these changes affect public companies and publicly listed companies?
Right, we did answer.
Yeah.
We did answer Cohen. So what Amanda had indicated is that the companies have so there are no exemptions. The exemption only relates to membership changes, but the public companies will have to file and notify us of the changes to beneficial ownership information, and they will have to provide who is the beneficial owner of the company. So only changes to membership information will be not allowed, will be exempt. But as it relates to BO information, that has to come in. So there are no exemptions for BO information. No company is exempt from filing that information.
Okay, and there's another question from Stancia Davis. In the with company C, if there were two shareholders, each with 50%, would both be considered beneficial owners given their 30% ownership in company
A? Say that again.
In the example with company C, if there were two shareholders, each with 50%, would both be considered beneficial owners given their 30% ownership in company A?
Yes, because the 30% ownership in company A, which is a company that was being incorporated, Or is it the other way around? All right, so
Yeah,
let me
that
go.
was it, Mrs. Bennett. Yes, it
Right.
was company A that was being incorporated.
Incorporated, right. So if company is being incorporated and the persons have 30% shareholding, yes, they have an obligation to declare. And if there are two persons with 50% shareholding, then both persons would be named. In the example that Amanda gave, there was only one person in that company C that had 30%. But yes, if company C had two persons with 50% shareholding, we're using an example of a company with shares, then yes, it would be two persons who would be declared the beneficial owner. Then yes.
Okay, and another question states, will these changes affect charities and PSPs?
Yes, and so we did answer, and just for clarity, yes, it will affect them, because now all companies must indicate who the beneficial owners are, not just companies with shares. And using the cascade test, where of course you would not have shares for those types of companies, but then you move to identifying who are the persons who have ultimate effective control. And in the absence of anybody meeting that definition, then you must name person or persons who are the persons in the highest position, management position, authority position in the company. So whether it's a church, it may be the board of directors, the board of governors, whether it is a civic organization, it is expected that beneficial owners must be named, whether one or multiple persons.
Just to follow up on that, since we're on the subject of charities, I see another question from Sharon. Do we have to provide notice of changes of membership for companies limited by guarantee? That is also a possible exemption. We appreciate that companies limited by guarantee often have a very wide membership. So providing us notice of change in membership every time a new member is added or removed may not be the most feasible option. So this is a possible exemption as well regarding notice of changes in membership.
Okay, there's another question as it relates to joint beneficial owners, but I'm not sure, maybe the person could just retype that particular thought process as it relates to the joint beneficial owners. All right, so the Companies Office, there's a question about credit unions, but remember the credit unions aren't registered under the Companies Act. However, the Department of Cooperatives and Friendly Societies, the Charities Act, there have been some amendments and their rules or regulations have been recently passed, and there are some new requirements as it relates to the provision of information, similar to what we are asking for. So that is something to watch from that end. But as it relates to the Companies Office, we would not have a direct impact as it relates to the credit unions. All right. Any other questions at this time? And just of note, we had mentioned about the changes to beneficial ownership information and the capturing of the beneficial ownership information. No, of course, it does mean that our forms will change. Our incorporation forms will change, or return of allotment form, which is used to capture new allotment of shares, will change. We will also now have a change in beneficial ownership information and membership information form. So that will be a change as well in terms of the documentation submitted to the Companies Office. So that is a change that you will also see coming out, and which is why the sensitization sessions will be ongoing. Okay, no problem. Thanks. I see that you've typed the clarity as related to the joint ownership. Okay. All right. Okay. Right. Are there any other questions or any other concerns anyone wants to raise at this time?
I see Soshana, is it Soshana or Tracy C? Sorry, Tracy C asked the grace period. Will there be a grace period to comply with the amendments once the act comes into force? Mrs. Bennett, since that's operational. We are
Well,
asking everybody though.
right, so, Tracy, yes, one is proposed, but, we're not able to indicate if one will be allowed, we are not sure. But what we do, we can indicate that we will be, it will be in the public space, so nothing will just happen instantly. So we're not sure if the recommendation to have a grace period is going to be passed, but, whatever the outcome, whether there is a grace period or there is not a grace period, there will be, adequate notification that the changes will take effect on a certain day.
And just to add, that is a part of the purpose for the sensitization sessions as well, so that you're aware of what you will be required to do when the act passes. So you are not just, the act passes and then immediately this is the first time you're hearing about all these obligations. We are doing our best to ensure that members of the public are aware of what obligations are to come. So when the act passes, you are ready to comply and ready to, do your filings. So that is also a part of the reason for these sensitization sessions as well.
And of course, to appreciate that, this is very summary, and so there will be more detailed ones as it relates to the forms, as it relates to the role of the new unit in terms of its inspection and verification, and of course, the more detail as it relates to what is in the actual proposed amendment act. All right, so there's a question as it relates to what is the procedure in the circumstances where the beneficial owner is a nominee shareholder. So the nominee arrangement, also the proposed amendments, that arrangement has to be declared as well. And so that is one of the proposed amendments where nominee arrangements have to be declared. So it means that if that is the situation where the beneficial owner is a nominee shareholder, there will also be a form to declare that information. So that detail will also be required. It's also be one of the provisions that are coming up. The other question was
sorry, Mrs.
Yes,
Bennett,
go ahead.
To that question about the nominee shareholder, what the form will essentially require are details on the nominator, right? So we would already have the nominee shareholders information because you would have completed that on the form as normal. But the schedule, which we refer to tentatively as the nominator schedule, you would provide all the information of the nominator, that is name, address, occupation, nationality, essentially the same information you would be required to provide for the nominee, you have to provide for the nominator as well. So that would be the essence of the form that you must complete once there is a nominee shareholder. Just to add.
Thanks, Amanda. Can the submit? All right. So the other question related to whether the submissions will be facilitated online. As it relates to new incorporations, you are able to file new incorporations online now. And so right now on our company's office website, you are able to file a new company online, indicate who the shareholders, directors, beneficial owners are. And so in similar fashion, as it relates to incorporation, as it relates to annual returns, which comes under the umbrella of change documents and, for instance, return of allotments that relate to the new allocation of shares, that information is not yet, you're not able to file that online. We are hoping that well, we do have a lot of plans in place to have annual returns online, but it may not be at the same time as this legislation is passed. But as it relates to new incorporations, definitely that can be done online. Right. So there's a question as it relates to The secure portal, based on the information that we are collecting, yes, we are exploring that. And the possibility of that, the beneficial ownership information be done online in a different registry is being explored. So we are very mindful that the data that we will now be collecting, is highly sensitive. And of course, the security risk with a paper system versus a electronic system. So it is definitely something that is being discussed. Okay, so the access to the beneficial ownership registry, whether there'd be a cost associated with it, not at this time, not proposed in the act at this time. So as it relates to the access to the BO registry by competent authorities and law enforcement, there is no charge proposed at this time in the proposed amendments. Okay. All right, I'm not seeing any other questions.
Just would remind everybody to complete the survey. Please, we crave your indulgence on that one. We really require your feedback just to inform future sessions, sensitization sessions that we will have. It is important that you tell us what we can do better, what other ways we could use to bring this information across to you. So we really encourage you to complete that survey. Thank you so much.
Okay, so there's a question whether we'll be sharing the presentation. Yes, that can be arranged. We will ask, we'll have our PR officer reach out to you, and you are also able to reach out to us if it is you're not seeing it coming to you. Right. Okay. All right. I don't know if there are any other questions. Okay, well, I may have missed. Okay, I may have missed one of the questions. It says, what about financial institutions wishing to access the register? Will there be a cost? And for the financial institutions, there is possibly going to be a proposed cost. However, we're not able to say at this time if that will be included. But definitely, what is now proposed is that access will be free at this time. And of course, we appreciate that that could change. But for now, what is proposed is free access.
Also, just to add, on a separate topic, sorry, back to the survey. I know I keep going back to the survey, but PR is telling me that in order to receive a copy of the presentation, it would be great if you could complete the survey, which would request for your email address. From there, we would send you a copy of the presentation. So again, another reason to complete the survey. Please go ahead and complete that survey at your earliest convenience. Thank you.
Okay.
just giving you all a few more minutes to see if there are any more questions. Someone's asking if the survey could be reshared. Sure, I think I could take care of that one. It was posted earlier on in the chat, but I will repost once more. Let me just see if I can, and also I think our PR team will also be resharing it in the chat. So just give it a second and the link should be back there. Should be reposted shortly. All right, for some reason, Kawane, here, I'm not able to reshare the link. It's not allowing me. If you could just repost the link to the survey in the chat so everyone could see it. We have a comment here from one person. I believe it would be good if there are provisions for a regulated entity to have access to the beneficial ownership register in the instance of entities regulated under the FSC or BOJ Acts. So that was just a comment, I believe. I don't know. Oh, they went on to the investment advisor, central depository, et cetera,
Right, so those persons will be able to have access. However, it is a type of access that will depend on the entity. So where, for instance, the Act will speak to law enforcement and competent authorities, these other class of entities will have a particular type of access and may only be able to verify information versus being able to see all information. So it would mean that they would have armed in their possession particular. So there's, for instance, they'd have information on Ingram Hensley, Bennett, and so they'd be trying to verify my specific information versus being able to have access to all the information that exists in the register. So that is what is contemplated for persons who would not fall under the umbrella of law enforcement or competent authority.
All right, so the survey link was just posted again. For those who didn't get it the first time, it's now down below. Seems like the PR team reposted it. So please, as I said, go ahead, complete the survey. Thank you. Just giving you all a few more minutes before we conclude for the afternoon. We had completed the presentation a bit ahead of time. So we're just giving you the opportunity to ask your questions, any comments you may have. The floor will only be open for a few more minutes before we close for the afternoon. I see a comment there. I point this out for the benefit of investors who may want to invest and would need to know as a matter of order who are the major beneficial owners. Yes, we agree. Thank you so much for your comments. We're glad that you all enjoyed the session and it was informative. As I said, as Mrs. Bennett said, and as I have said, this is just one of many. When the act is actually passed, the sessions will get much more detailed. So we encourage you to stay tuned, follow us on all social media applications, Facebook, Instagram. I don't think we're on TikTok yet. Right, Colleen? I don't think we're on TikTok yet, but follow us nonetheless on Instagram, Facebook, Twitter. We're on all of them, and we let you know through those social media websites and apps when these sensitization sessions are taking place. We think that's the best way to reach all of you. Not sure how many persons listen to the radio anymore, so perhaps that's the best way to get through to everyone, to let them know that we're having a sensitization session. So we encourage you to follow us on those platforms to stay informed. As Mrs. Bennett said, it will only get more informative and more detailed from here. So just encourage you all to follow us. Thank you all for participating in the session today. I think we can go ahead and close. We really appreciate those who commented and those who posed questions, and just thank you all in general for listening and for attending. Final word of encouragement to complete that survey. I cannot repeat it often enough. We really do want your feedback. So thank you again. I'll leave it to Mrs. Bennett for the last words, but thank you once again for attending and for participating.
Right. Well, just to mirror Amanda's sentiment, yes, we are very appreciative of the numbers that are out today. And we are encouraged by those numbers. And we do appreciate that this is a very topical area. And just to reiterate again, thank you for coming out. Look out for the other sessions. They will be more detailed and they'll be more specific. So for those of you who file with us regularly, we will have, for instance, a session on forms because of the extensive changes that are going to come to the forms. And of course, we will have one on compliance because you will appreciate, I would have mentioned that the sanctions are going to be changing and increasing. So the sessions will become much more informative. They will be more pointed to specific areas of the amendments. So please just stay tuned and of course, reach out to us if you have any concerns that you may not have expressed in the chat. We are here to help you. And we definitely appreciate all your attention today. So have a good afternoon, everyone.